Alright, good morning. Let's start the class for today. We are doing tort, a brand new subject, but it is still a subject within your general paper. In general paper, you have two subjects. One, contract, and another one, tort. So we have done contract. So today we'll be looking at tort and we'll be taking about 3 to 4 class, something like that, okay, to finish off tort for this area. So as usual, I will give you an overview what is tort about, and then we look at some of the past year questions, so the type of exam questions that you'll be getting, same like what we did for every new subject. Then we'll start off by looking at some of the liabilities, or what I say, the cause of action, the main area, in particular 2A, question 2A in your exam. Okay, now let's start. So we're doing tort. So a little bit recap of what we have done so far. In particular, on Monday, we done the last lecture on contract. We look at damages, how we're going to claim Hadley-Baxendale remoteness, pecuniary, non-pecuniary, LAD and damages. We have cases like QB Electronics, deposit part payments, and we have unjust enrichment cases like Dream Properties and Atlas Housing. And also we look at how are we going to use and write up statement of claim. So whatever we learned in the chapters on pleading in your Civil Procedure Order 18, so all those rules apply here. So as usual, today we look at, like I said, an overview of your tort. Now, what is tort in the first thing? Tort, I think students are normally okay with general paper. The only problem with general paper is that they don't estimate enough time. They didn't do enough practice on their time management. Because we know about contract, that is like your first subject that you study in your LLB days. I think you study torts in your second year. So now that's like tort of negligence. So the one that you'll be looking at in here, it's same thing like motor vehicle accident, you fall down, you fall down, motor vehicle accidents, someone knocked someone down in an accident, someone died, someone broke his hands, and then they'll ask you what are the things you can claim, you cannot claim, and then you do a statement of claim against it. So the duty of care, the breach of duty, these sort of things, which I'll explain a little bit more on this sort of area, particularly what you need to pay attention on. So that is like the whole thing. So that's the general paper. For first part is the contract. Now you see, in LLB days, we always look at, what is contract? You have offer, acceptance, consideration. What makes up contract? How does a contract come about? So we look at, is that an offer? Is it an ITT? Is it an acceptance? Is that consideration? And I tell you that it's like the LLB days. That it's not in your CLP. CLP is a very technical paper. They are not interested in how well you can write down on your this sort of, concept, rules of contract. It is not that important, but how do you apply and use it in a question? So when we look at the contract, and I said the first thing first, you look at when was the contract concluded. And when the contract is concluded, and we look at whether there is a breach, whether there is a fraud or misrep, whether there was an illegality, and then what are the things that you can claim. Now, same thing in tort here. It is not so much of what makes up, duty of care, what is a tort things, but what about there is a tort, all right, and this guy got hit by a car. So what is that? There's a motor vehicle accident. What sort of duty are we looking at? What is the standard of duty? Maybe it's not motor vehicle. Maybe it's like medical negligence. Okay, in recent years, medical negligence is something quite hot, not just in exam, but in our legal field. And you see they are starting to have lawyers that tend to be much more specialized in this kind of medical negligence cases. You don't really see much of this in the olden days, okay, in the past. But now maybe they are more on medical negligence. People go for private hospital, things like that. So there are areas in this one that we need to know. So The exam is not so much about how well you can write about what is tort, what is negligence. You do still need to write about it, but not a lot. Now, what happens if there's a tort? What are the things that you can claim? All right. What are the things that we are looking on? Okay. What are the things that whether is it claimable, not claimable? What are the defense? What are the contributory negligence that did this plaintiff contribute to this accident as well? So these are the factors we need to look at based on the facts of the questions as well. Right. You will find that, okay, the thought question is not longer, but they have more things that you need to look at. So later when we look at the questions, that you have an idea. Now, same thing here. Thought. In contract, you have 1 hour, 30 minutes. In thought, you have 1 hour, 30 minutes. Your time management, like I said, must be tip-top. You must be on time. The problem is, student always, you start with the contract because there's the first question, isn't it? They spend too much time on the first question, maybe 2 hours. Ended up, thought they only left 1 hour to do. And when they left 1 hour to do, and they couldn't finish 2C, which is your statement of claim, and you wasted about 15 or 20 marks there. Now, let's look at some of the past year question. All right. Where is it, your past year question? Right. So let's look at, okay, just simply choose one of it. Now you see, when it comes to contract, normally it's like a storytelling. They have a question, a scenario. Like this 2020, question 1. This is almost the same based on the case of Merong Mahawangsa. So I asked you to read that case. So this is the question that based almost on that. So you see that the question is quite short, but started from 2021 or 2022. The contract question is quite long. And I'm assuming it's based on the same examiner that said it. So like I said, every examiner has a particular style of setting a question. From that kind of question, you can see the style that the examiner, what kind of person he is. You know, maybe you're not that sensitive in this area, but I tend to see much deeper and I can sense, okay, he is this kind. He liked this particular style of question. So you can roughly know what is it about. Okay, so you see, in contract, there is always the question, then that's it. But in, you see, this is the one. In thought, you have like a questions. Not only that, you have to A to B. You still have other documents, supporting documents, like your medical reports, police reports. Okay, this is quite short. Some of them have like accident sketch plan. Let's see the one. Okay, this one, question 2. So you have the questions. This has more. So you have appendix A. This is the statute of section 101 Local Government Act. Then you have police reports. Then you have report of overhanging branches by the tree management units, medical reports. Okay, so they have many kinds of reports. Let's see a few more. Different from contract, where contract itself is just the question itself, straightforward, and then you answer. So again, question 2. Sketch plans. Very often you get sketch plans. I know when I was working in Ministry of Health as a drug enforcement officer, I always have to draw this. Whenever we go into a certain place and do a raid, R-A-I-D, raid, meaning we confiscate certain products or medicine that were found liable, not registered, illegal, and then we have to draw just like you found a dead body. So the sketch plans, okay, if let's say this is a sketch plan of an accident. So they will draw, okay, on the road, this road is to where, this road is to where, and then whatever, accident here got a house, here got what, okay, all this sort of thing. If it's like a dead body that you found in a house, then you draw the sketch plan. It's like architecture, interior design. You draw the sketch plans, an overview of the sketch plan. So this is the kitchen here. Then this is the living room. So the body was found in the bathroom. You put an X there. So here the key, you put X dash dead body. Or very often in drug cases. Okay, you found drug in a house. So you draw a house plan. Drug was found here in kitchen, put an A1. Drug was found in living room, put A2. Drug was found in bathroom, put A3. Then you draw. So you need a sketch plan. Why do you need a sketch plan? This need to be tendered. Now you need to use the correct legal term. Tendered, T-E-N-D-E-R-E-D. Tendered in court. Okay. When we do criminal procedure, like yesterday I talked to you about, cross-exam, chief exam, things like that. When we come to criminal procedure, I'll explain more to you on the flow process. You need to have a big picture, know the whole flow process, or else you won't understand criminal procedure. You have problem. You end up memorizing, not knowing anything about it. So you need to know, okay, what is it? When to tender those sort of documents, okay, the sketch plan. And when you tender those sketch plans, okay, in criminals, we have a particular way of labeling it: Exhibit 1, Exhibit 2, P1, P2, or we call it ID1, ID2. Okay, we come to that when we look at criminal procedure. But the thing to tender this kind of sketch plan is to inform the judge. Is for not only the judge, is for the investigation officer, or what we call as IO. Okay, you come across this term in criminal, IO, investigation officer, to know what happened, where is it, so that he can have like an overview. On top of that, you will see like accident places. You have like the police from, the traffic police, they'll have a camera and take picture of the accident, okay, the dead body, or even in the criminal cases where the dead body was found. You will watch it a lot in like Korean drama, whatever, in Netflix. Okay, the picture, and then the drugs was found here, the murder weapon was found here. Why do you have all this picture? The picture is to tell the story so that it helps the investigation officer when investigating. Not only that, those picture is also a bahan bukti, an evidence to be tendered in the court. Okay, so from here you have a questions, and then you see appendix. They will say that appendix here. Okay, sketch plan, all this thing. So from this sketch plan, it is not here just for your viewing for fun in exam. In exam, you need to look at the sketch plan. Is there any information that we can deduce from the sketch plan? As a lawyer, like I always tell you, I want you to learn from now on. You need to make that step. You definitely need to make that step. Now, if for first year to third year of LLB things, you can, hoo-hoo-ha-ha, memorize some answer, essay, and then, study for the past 3 months, you'll pass. Yes, you can. But for CLP, now it's the time for you to make that step. You need to think as a lawyer and think like an adult. And you need to be consistent in your studies. This is a very technical paper. Just by studying for the last 3 months, it's not enough, and you will find it very hard. So start to do it now. What can you look at? What you found from this, sketch plans? What about here? Medical reports. What can you read? It is not here just for fun. So you need to read it and see if you can deduce any information and summarize any information. So from here, you need to know what is the current condition of this guy. What are the things that we can claim? Okay, what does it mean by quadriplegic? What does it mean by continuous daily nursing care? Does that mean that we can claim a little bit more? Or is it the claim is a little bit limited? How about police reports? Okay, so what do you need to get from police report? The name, the age, the occupation, what is the time? Okay, what happened from this police report is the one that is made by the defendant. So from the defendant's side of the story, what did he say? Okay, he said it was not his fault. It was the plaintiff's fault. Okay, then does it mean that there is some sort of contributory negligence from the plaintiff? Would the court apportion the damages? So you need to look at from a different perspective. Now, let me tell you something that I encountered yesterday. Yesterday, I got a text, okay, because you all are current, my group of students. Yesterday, I got a text from my ex-student. So one of my ex-students, I always tell this to my students, I always say this to you. I said, in your LLB days, when you are in the uni or colleges, you are always being spoon-fed. Okay, this is the case, that is the case. You don't even have to search for the case. And you don't even have to read the case because they will summarize whatever make in the book for you. I know, I understand, okay, this is what student wants. This is what the college has been, doing for this year. But this is CLP and you need to make that step up. Now, of course, in CLP, your study manual, you can read that summarize, but it's not enough. That is why I provide a case to you and I want you to read it. Look at the legal principles. Look at the reasoning behind it. What are the things? How can you compare the similarity and differences in the fact? Because when I know a lot of you are working right now, okay? Because when you are really a chambering student, not only when you are a chambering student, when you are a lawyer, you got a new case, you're handling a case, you need to search cases, you need to look at facts, you need to, look at case law. You'll be thrown in the wild. Well, of course, sometimes here and there, you may ask some help from your senior or your, someone that is much more well experienced than you. But you need to be able to stand on your own feet. That is something, the step that you need to start to adjust and accustom to it right now. Yesterday, I got a text from my ex-student. And she texted me this question. She said, Dennis, can you help me? I'm working right now. She said that my boss has given me an assignment to find on this thing. She tell me certain topic. So then she said she had been looking for the case law for past 5 days. And she couldn't find it. And she asked me if I could help or have any way, is there any other resources she can find. So that is one thing, because right now, when you are in the LLB and CLP, you don't really need to find cases. I provide you the cases. Of course, I give you the cases. I tell you which part to read, but I want you to start learning how to read cases. Even in your LLB, you don't even have to search. You don't even have to read cases because they summarize it for you. So my student, she texted me on this. So then I confirmed back the question that she asked me. Then I said, is this the thing that your boss passed to you, wants you to do? She said, yes. So I look at it, okay, I know what is it about. So I say, okay, look at this section. What is it about? This. And then she said she also found this section, whatever. And I just want to share with you, okay? Take a 5-minute share with you. And she also found this section, whatever. And she told this to her boss. And she said the boss seems like not satisfied with it. So wanted to find more information in this area. Now, the issue that she mentioned to me was this, okay, is with regard to a will, W-I-L-L, will, wasiat, okay, will. So, the will, okay, the issue was, all right, the issue, okay, I'll just tell you what is the issue. The issue was this. If you make a will when you are single, okay, when you married, the will is automatically revoked. Okay, so let's say now you are single, you make a will, and when you married, yes, the will is automatically revoked. So I think the boss was handling a case whereby the boss wanted to fight on the possibility on the point whereby, is there any possibility whereby a will that is made when you're single, it is still valid after marriage. So she passed this assignment to my ex-student and wanted her to look up on this area. So she come and asked me, she said she'd been looking for it for 5 days on this area and what to do, this she cannot. And I said to her, okay, it is quite common now. There's something, another soft skill I wanted to teach you all. There is a book, I read a lot of books, okay, there's a book by Ray Dalio. I don't know if you all heard about this guy. Let me see. Called Principles. Okay. And there's also a book called about, what is it? Truth. What is the name of the book? Let me think about the name of the book. They talk about what is truth and what is fact. Okay. What is truth and what is fact? As a lawyer, sometimes we are very accustomed because we wanted to fight. Let's say the boss here, okay, using the situation I talk about my ex-student. The boss, she's fighting on a case whereby she wanted to prove that is there any possibility a will that is made when they're single, marriage is not revoked, meaning after marriage is still valid. But as a lawyer, sometimes we need to know what is truth and what is fact. Or else we will be so deep in thought in that particular fact or area and try to twist it to fit into our agenda. If the truth and fact is so obvious it is like that, then take it as it is. It is the same thing. Okay, now I relate it back to a bit of your exam question before I finish off the story with my ex-student. It is the same thing with your exam question, whatever. If the act, if the statute, if the law is like this, okay, stick to your principle. Say it, cannot claim. That's it. You see, sometimes students end up in thought because they wanted to claim that thing because, okay, they said that now you are advising the plaintiff, so wanted to claim, end up they twist the law, okay, as if to fit into the agenda. It doesn't have to be able to claim anything. If it cannot claim, then cannot claim. If it cannot claim, why? Because this statute, this law say this. If it can claim, then what are there? Is there any case law? Is there any legal principle? Is there any reasoning? Don't start to assume and twist it, the law, to fit into our agenda. Okay, you must remember this, not only in exam, but in practice scenario when you're a lawyer. It's very common because when you're a lawyer, let's say you are fighting for this case. You wanted this, like I said, my ex-student scenario, you wanted this will to be valid even after marriage. So your thought is so deep in there, you will not be able to see any other perspective. You will end up perspective is something that you need to train to be able to look at from different kind of perspective. If you restrict and limit your perspective and keep thinking, okay, how can claim? Will made in single, revoke marriage. How? Your thoughts will always stick on that how part and you wouldn't be able to look at other areas. What other areas can we look at? When? Why? What? Where? There are other areas. Don't limit your perspective. But if it's so obvious, the statute is there, okay, the law is there, you have to accept the principles, the truth, like the book Ray Dalio in Principles. And there's a book on truth. I'll find what's the name of the book. I forgot about it. Okay, what is truth? So I told my students this. Because she asked for help. She said today she have to, present and speak to her boss about this. I said, now, I texted her, I use a voice clip. I say, now, let me teach you how you wanted to interact with your boss and speak to her. I said, you speak to her like this. I said, you tell the boss that you have looked it all up. And it is obvious, Section 12 of your Wills Act says, once a will is made when you're single, okay, if a will is made when you're single, once you're married, it's automatically revoked. Now, of course, the case that you're handling, now I'm pretending as if I'm speaking to that boss, okay? Now I say, of course, sir, madam, whatever, we are handling a case right now whereby we wanted to find ways, okay? Is there any possibility that a will made single even after marriage is not revoked? So far, I haven't looked at a case. There's really not I wouldn't say not a lot. I would say probably don't have any case in this area because the statute is so clear on this. But maybe we can look at it from a different kind of perspective. In Section 12, they said a will that is made when you're single is revoked when you're married, unless the will is made in contemplation of marriage. So meaning, when you make that will, let's say now you are single, but you have a very long-term relationship, boyfriend or girlfriend, you know you're going to marry her or him, okay? So when you make this will now, when you're still single, because legally you're still single, in your will, you write it in your will that say, in 5 years' times, I'm going to marry this guy, I'm going to marry this girl, okay? Her name, his name, what is it, okay? So you make this will with the intention of marrying this person. So the will, the distribution of your properties in there. So you have think about that future with this person in thought. But there's something that you can fight on there. Assuming The boss, okay, my ex-student, the boss, okay, is handling this case, and the will, if let's say the will has this sort of things, okay, then maybe we can think about this route of contemplation of marriage. Because there is no definition on contemplation of marriage. How does it mean that contemplate or no contemplate? Does it mean that I must write the name of my future husband or future wife in there? Obviously, if you ask me, how strong is it if you don't write the name of your future husband, future wife in contemplation of marriage? The will is very weak. But if it's weak, it's still something you can fight. Okay? But if it's like so obvious statute say cannot, can or not, then obviously you cannot fight already. So I told my student, try to speak to your boss like that. You try to look at this possibility, look at the will. What's it make in contemplation of marriage? And you maybe wanted to fight and argue, what is contemplation? It was not defined. Does it mean I must write the name of my future husband or wife in there? All right. Yes, if I write, it's much stronger. If I don't write, it's very weak. Then it's still fight. Maybe at that time when I made the deceased make this will, he or she has a very long-term relationship that she knows she will marry the guy or he know he will marry this girl. So that, of course, is some sort of contemplation, even though it was not stated in the will. Maybe you can think from that perspective. So I told my student this and tried to ask, today when she present to the master, the boss, okay, try to speak to her in this kind of way so that, no, sometimes lawyer like that, you got stuck in your mind so much, you couldn't look at other possibility. Same thing in thoughts, okay, in here, in contract. Now coming back to sorry, I take about 5 minutes to share a little bit, just to give you a little bit of story about what happened with my student. I just got attacked yesterday night with this one. So same thing with here. In contract or thoughts, when you are advising the plaintiff, let's say the plaintiff is this Henry Holman, right? Why do they give you this police report of defendant? Because this police report of the defendant give the other side story of the defendant. So just because you're advising the plaintiff, okay, doesn't mean that you must cite and say, defendant is wrong. Everything can claim. And you twist the fact, twist the law, twist this and that. No. Always, as a lawyer, you must remember line thing. Same thing like when we look at professional practice, our ethics rule. Okay, some lawyer, because they wanted to win so much, they lie in courts and start to, even though they know this is not the law, okay, they lie, they didn't wanted to tender this. You will see lawyers like that. But to me, honesty is the most important thing. You must be able to speak to your client, speak to your, whoever it is and say, all right, this is the law. Okay. Now, there's an art or something always you all need to start to learn now, especially you're in a working environment. Now, of course, I'm a little bit more older than you all. And the art of speaking and communicating, to me, I find it quite strange. There is not one of these module or areas to practice or study in your law degree. Whereas in law, as a lawyer, you speak the most. Not only you need to speak to the court, you need to be able to communicate with your client. When I was studying for pharmacy, in the second year, we have this communication module. And we have to record down, we have to do role play in front, like as if we're speaking to a patient, how we can calm him down, how we can advise him. If he agitated, what can we do? I think same thing as a lawyer. How can you talk? Imagine the family of the deceased come and talk to you, please help me. Then you start to talk, cannot claim. What do you think the family will think about? How do you talk to them? The art of speaking, communication skill is really something very lacking. And I really hope I can, teach you more on this one. So when you talk to the patient, the clients, okay, you see, the defendant always this. You cannot be telling the plaintiff, cannot. So you tell him straight forwards, okay, what is the law is about? This is it currently. Maybe this is what they can claim. But there is also another area that you say, there's a thing that we need to anticipate. Use the word, you can say. We need to anticipate some defense from the other side. Because in the defendant police report, he said you did this. So the court may look at this possibility and apportion the liability, meaning instead of saying the defendant is 100% liable, so now it's 70% liable, 30% plaintiff also liable. There is some sort of contributory negligence from your side. But you always say, don't worry, we will fight the best and we will find cases to argue and cite on us so that I think we have a very strong case on this area. But if you think sometimes the case is weak, then be honest with your client. I think this case is a little bit weak, Mr. Lee. I think for your side to be able to claim for this, because the worst thing ever happened, and I've always seen that before, is giving a false hope to your client. Never ever give false hope. You see, you give false hope to it, end up you cannot do this, cannot do that. It's even worse. Straight away tell them, just like that. Section like what my ex-student, a will made before married when you're single is revoked when you're married. This is the law. Okay, but maybe we can look at it. But what's the possibility? Just like when you look at, you go to the doctor, let's say this guy has cancer, ask doctor, what's the chances of me recovering? The doctor will say, oh, don't worry, 100% you recover. False hope. Now, of course, sometimes it works in medical because of your emotions and positivity, but law is different. Okay, never give false hope. So again, the story I wanted to tell you is this. Don't always, as a lawyer, think from a different kind of perspective. Anticipate the defenses that the other party will make. Stick to the law. Be honest with your client. Stick to the law. If can. If cannot, cannot. Okay? If can, then why? If cannot, then why? You must have a reasoning. Don't twist the law of fact just to fit into your own agenda. Okay? So now, if you see that, okay, these are the possibility. Now, something a bit different from thoughts and your contract is this. Contract, when we look at last few weeks, I said you have 1A, 1B, and 1C. So if your contract, you see that 1A normally is the cause of action. 1B, sometimes 1A is cause of action plus damages. So for this one, you see cause of action plus damages. Sometimes 1A is just cause of action, 1B is damages. Sometimes 1A cause of action plus damages, 1B is some critical thinking question. And if you look at 2023, 1A is just very short 10 marks kind of cause of action. 1B, 20 marks or 25 marks on damages. They have to look at many things: piano, cash, painting, house. Each one we need to look at the remoteness of it. 1C is always statement of claim, 15 or 20 marks. Now, for tort, the question is much more fixed. 2A is always on the possible cause of action and defense parties. 2B is always on the damages. Can you claim? Can you not claim? Can you claim this? Can you claim that or not? 2C is always on statement of claim. Like I said, always students couldn't finish 2C. They'll start off by writing in the High Court of Malaysia, time's up. That's it. They lose 20 marks. It's not hard. So your time management, very. You must at least reserve 30 minutes for doing statement of claim. When we do time training, mock exam, past year question, I will teach you how to, time yourself on doing this and what is our strategy. Okay, we talk more about that. So now, this other question. Now coming back to the notes I give you. So now we are thought notes. So there are quite some cases I want you to read, and then don't worry, I'll tell you where to read it, how to read it. So here, this is a thought. Your question flow is always like that. You start off by looking at preliminary issue. What are preliminary issue? Is tort criminal or civil? It's civil. Is contract criminal or civil? It's civil. There are civil matters. So we have just completed on Tuesday our preliminary block of chapters: parties, services, limitation, read, mode of compliance, pleading, amendment of pleading. So what is it? It's the things that you need to make sure they are in place. Are the things that you need to make sure they are correct order before you start a civil claim. Sometimes in tort questions, you get some sort of issue in this area. Okay? You must make sure you get the courts right. So in contract, when we do this statement of claim, so we need to look at, if you are claiming for more than 1 million, then you go for high court. And in tort, very often the question that you get is motor vehicle negligence. And if motor vehicle negligence, they're claiming for 5 million, should you go session court or should you go high court? You go session court, section 65, motor vehicle negligence, unlimited jurisdiction. So make sure you get the court right so that in your statement of claim, you got it right so that you start to get marked. Check sometimes, is there any limitation issue? The question will say they come to you, this accident happened 5 years ago. Or we don't use contract anymore. Now we are looking at Civil Law Act. So next week when we do damages, we look at Civil Law Act. Okay, so Civil Law Act in particular, sections, what is it? Section 7. Section 8. Okay, Section 8. When can you claim for the death? Okay, against the estate, all these sort of things. Section 8. So we look at that as well in your civil procedure. Claiming against estate, claiming against the deaf person for tort of negligence, this sort of thing. Okay, this is where we're gonna use it. I spoken a little bit about it. I say we look at it more on tort. This is where. So get your parties right. Because sometimes you have question coming to you. It says his son is now in coma. His son is now in paraplegic. Paraplegic means, hands, legs all cannot move freely. It's like vegetables. Okay, vegetable. All right. So now the father is claiming on behalf of the son. So father is claiming on behalf of the son. How do you write the name of the parties? So what about husband involved in an accident, husband die? Wife now wanted to claim for dependency claim from this tortfeasor. What is tortfeasor? Tortfeasor means the person that knock you down, the defendant. Because it's tort, we call it tortfeasor. So we need to check on this one. Then your 2A question is always here, liability. Okay, these are the possible. Actually, there's number 9, one more. Okay, number 9, you can write it statute. Okay, sometimes just now if we look at there's this DBKL statute, they ask you that because the DBKL they didn't cut. That was it. Because now we keep raining, right? Because now it's a change of season, so you have all the trees that fall down, crash on people and die, crash on the car. So now they crash on this person and die, and this person's wife sued the DBKL why you didn't cut the tree, making it a danger so that you foresee it will fall down during monsoon season. Okay, so now he's suing DBKL. So how? Sue DBKL because there is a statute and act that DBKL need to trim this kind of tree, do this and do that. So sometimes there are questions based on statute. So you put then number 9 here, a statute like depending. Sometimes they provide you the statute. So there's also a certain statute you need to know, which I'll give you here. You see here, Occupational Health and Safety Act and Employee Social Security Act. Okay. Occupational Safety and Health is OSHA. Last time, when you read certain books, they have, I think in your study manual also as well, you have this, what act is it? Let me see, what act is it? The old one. Factories and Machinery Act. This is the old one. They have already repealed it. And last time you have this. You have Occupational Safety and Health Act as its own, 1994. You have another act called Factories and Machinery Act. But they repealed it and put this into Occupational Safety and Health Act and update it, combine them together. Now everything is called Occupational Health and Safety Act. In developed countries like Singapore, UK, when you wanted to do any big renovation, or not only renovation, in big factories, every area, every field, they need to have a health and safety officer. Now, I think we are okay. We are much better. Because if you go like Singapore, they are very strict on this one. Like, let's say you're building a construction building, you need to do this, you need to do that, you need... we are still okay. We do have, but maybe we don't strictly follow the law. If you go to country like India, things you see, they climb here, climb there, it's like there is nothing as health and safety. So if this person is to make sure they put a person there, is to make sure, or they not only put a person there, the employer is to make sure that the working environment is safe for all the employee. Not only in the office. If you ask the employee to go for a work field trip, you must make sure that place that you're asking him or her to go is also safe. Okay, there's also another one that you will know is this one, Employee Social Security Act. If you're already working, you know every employee need to pay not only first income tax, you need to also pay your EPF or KWSP. You also need to pay what we call SOCSO or PERKESO. So these are like the insurance you pay to this PERKESO, SOCSO. In terms you fall down when you are working, let's say you go to the office toilet and it's slippery and you fall down and you hit your backbone. You can actually claim from SOCSO. All right. Any injury that you obtain from work, you can claim from SOCSO. This is like an insurance, so don't blur pay. Don't know how to use it. All right. So SOCSO, you have to pay. Your employee have to pay depending on your salary how much. So it's not so much. It's less than 100 ringgit lah. Okay, sometimes 7 ringgit, 10 ringgit, I forgot how much already, 10, 15 pence, okay, not a lot, okay, this is your SOCSO. Now, for exam purposes, for 2A, okay, your question won't be here. Like, remember when I talk about professional practice, I say in your ethics question, the possibility of you getting an LPA question is 100%. The possibility of getting ethics question is 70%. The possibility of getting duties of counsel, it's less than 50. Same thing in contract. Even though we look at voidable, I say the main area we need to focus on is fraud and misrep, breach of contract, illegality. For here, okay, the main area, now negligence is just as a general principles on how to write negligence. The main area is definitely motor vehicle, nuisance. Now, there is no more industrial accident. Okay, you can change that one, replace that one to OSHA, just now the Occupational Health and Safety Act. Okay, occupiers liability. Occupiers liability, they won't have a question on its own. It will always combine with negligence. Okay, medical negligence. Okay, I spotted this question a few years ago as well. Now, I don't think you will get solicitor negligence. Now, I gave you a case here today with regard to solicitor negligence with Nyonya Aye. This is the one that I talk about in professional practice, duties of counsel. I said in Malaysia, advocate and barrister, solicitor, we are not immune. We can be sued. So this is the one of the case whereby the lawyer got sued but for negligence. Okay, medical. Vicarious liability, you will not get it on its own, okay? It will be combined with some other like negligence. The possibility of you getting a motor vehicle question is quite high, okay? It's always they like to motor vehicle. Rylance Fletcher, I haven't seen a question. I don't think so. So the main one, definitely negligence is like a general principle. Motor vehicle, nuisance, medical negligence. Occupier vicarious is combined with other things. Once you look at the liability in question 2A, you always need to check, is there any defense? This is what, you need to be able, as a lawyer, you need to think from different kind of sides. Your thinking is what I call, it must be like a 3D. It cannot be just 2D on one-sided. Okay? Your thinking must be from a different area. Okay? You must be able to anticipate what sort of defenses that the other party will raise. Maybe your client, your plaintiff, this plaintiff has contributed to the negligence. He was drinking while driving. For let's say a plaintiff, and now he's involved in this accident, so obviously he's wrong in the first place. But there's also one thing. Later we look at some cases. Even if it's contributory negligence, we need to look at what sort of thing is contributing to it. Now you need to start to think much deeper layer. Go down into, rather than just on the surface itself. Go down much deeper. Always ask yourself, can or not? Why? Anything further? Think deeper, challenge yourself. Then after that, question 2B is, the damages. Can you claim for the damage of the car? Can you claim for this medical bill? Can you claim for the because you stay at home for 2 months, no salary? Can you claim? Okay. Now this is where special damages in your pleading, like we said, must be pleaded. General damages, no need to plead because it's up to the court, the registrar, to decide how much. And then we have something called aggravated damages. We look at it on next week on this area. Okay, so these are the things. So your answer is always from this flow, this area, go down this area. All right. Now, just to give you a little bit area, in your exam questions, your negligence can be a personal injury claim, meaning this person got knocked down by this defendant in a car accident. So broken hand, broken leg, stay in hospital for 6 months and then lose the job. Okay, now come out already, need to do a rehab. So meaning the plaintiff now wanted to look for you as a lawyer to advise him what he can claim. He's still alive, the plaintiff. It is also possible, the question say the plaintiff knocked down and died. So the wife of the victim now come to you and say, I want to claim against the defendant because my husband every month give me 5,000 ringgit for household expenses, for the children's school fees now, and I'm not working. So now my husband died already. So who's going to support us? So I wanted to claim against the defendant, the tortfeasor, for negligence causing death to my husband. So can he claim this 5,000 every month that the husband give to the wife and claim it against the tortfeasor? Can he claim, what about, okay, these expenses, that expenses, this house loan, that house loan? All this sort of thing. So we need to look at. So the possibility, it depends whether he died or not died. So we need to look at it. So what are some of the special damages? What is special damages? Special damages where you know the exact amount that you wanted to claim. There is an exact amount. There is no need for the court or registrar to assess the damages. So this is it. For example, traveling expenses. What do you mean? You stay in a hospital for 6 months. Every day your wife take Grab to go hospital. Return to and fro, total is 30 ringgit. So times 6 months. This is the amount you want to claim. Personal items damage. For example, you're involved in a car accident. Your car was damaged. You need to fix it. And the cost for fixing the car was 20,000. Okay. Medical expenses. You got into an accident. You stay in the hospital. The bill was 70,000. Medical expenses. What if that medical expenses 70,000 was paid by your insurance because you bought insurance? Can we still claim or not? Can we still claim for the other party? What if we go government hospital? Must we only go government hospital? I don't know if you all know. Okay, government hospital, we are very cheap. Okay, and I can tell you this because I work in the ministry. The standard and quality of the government hospital is on par with the specialist center, whether you call it Sunway, KPJ, or whatever out there. It is the same. The quality of the doctor, sometimes is even better than the private. Okay, so if I always advise, if let's say someone of your family members have some sort of things that you need to advise on, trying to go 2 ways. Open a file in your government hospital and also go for private if you have insurance. The only downside to government is because there are a lot of people going there. So that's why you need to wait. Okay, so you need to wait. I can tell you there is no hospital in this whole world whereby you can get branded medicine for just 1 ringgit. Your medication when you go to government hospital is just 1 ringgit. If it's specialist, I think it's 2 ringgit. No place in this world, because people don't realize the medicine that they give out to patients in hospitals. Some of them are branded, and the branded one, it can cost thousands, and you get it for 1 ringgit only. Okay, so I always, maybe I work in there before. I work in the ministry, so I know very well these sort of things. Okay, so these are the things we need to look at as well. Can you go government? Can you go private? Must you always only go government? Okay, the medical expenses. If you go government, what are the things you can claim? What about nursing fee? You got accidents, okay? Now, you need to stay at home for 6 months to rehab. And your mom was so worried about you, so she quit her job outside to come home and take care of you for 6 months. By right, your mom is getting a salary of 3,000 ringgit every month working as a part-time clerk. Okay, just like extra income. Because now she wanted to take care of the son at home, so she quit. For by right, 6 months times 3, she can get 18,000. Can you now claim this 18,000 on behalf of your mom from that tort visa? Okay, nursing fee. Funeral expenses, let's say someone die. The amount of money to do the funeral is 10,000. Can you claim from the tort visa? Memorial service expenses, you do a memorial, okay? That's the whole event costs 20,000. Traveling and accommodation expenses for funeral memorial. Traditional medicines. You were resting at home and then doctor suggests that, okay, you need to take this Chinese traditional medicine is very effective, okay, as has been proven, okay. The cost is maybe you go and buy every week, total add up is 20,000. Can you claim the Chinese traditional medicine from the tort visa? Loss of contribution by deceased to dependent. Okay, we look at that so as we go along. Home renovation. Because now you got into an accident, your leg are broken, amputated. So normally your room is upstairs. Okay, so now you need to renovate your house so that at the lower floor there is rail guard so you can, your wheelchair can move around. Your toilet you need to renovate so that the wheelchair can go inside. So that renovation. So if you see that all these things that you have exact amount, so you put it under special damages. Special damages, again, the amount of money you wanted to claim, you know exactly. But what about loss of general damages? General damages is you don't know how much. You tell them, okay, roughly this is it, and it is up to the court to decide. So loss of amenity, pain and suffering. You got into the accident, okay, and then very serious. You immediately go into the hospital and, a broken fracture here, fracture there, and the doctor need to sedate you and then do operation on you. So that pain and suffering, it is not something that is quantifiable. There is no value to it. So it's up to the registrar and the court to decide. So pain and suffering. Loss of amenity. You were a marathon runner and you love running, but because of the accident, you have to amputate your leg. So now you cannot run. So you lost the enjoyment of running. So there is no value to it. Loss of future earning. You were working as a lawyer, earning 20,000 amount, famous lawyer. But because of the accident now, okay, you have partial brain damage. So you cannot work already. And because of the accident, you lost your job. So by right, you should be earning 20,000 for the rest of your life, let's say up until 60 years old. Can you claim the money that you should earn for the rest of your life? Loss of earning capacity, okay? Right, you work as a technician where you need to climb here, climb there. But because of the accident, now your legs start to feel a bit pained. So after the accident, you still go back to work. But after you go back to work, you can foresee that sometime in the future you have to stop working because the pain now is getting unbearable. The leg pain because of the accident. So there is a possibility you can lose the earning capacity sometime in the future. So can you claim that from the tort visa? What about future care expenses? You get into an accident, okay, this guy, victim get into an accident, and paraplegic, meaning he cannot even move his hand and leg like Stephen Hawking, Stephen Hawking. So even you go to toilet, need to be, put that urinary catheter. Okay, we call it catheter. Okay, the bag for you to pee, for the bag for you to, to shit, whatever. Okay, you need someone to push you to the toilet. So you maybe need hire a maid 24 hours to carry you for the rest of your life. You maybe need certain equipment like wheelchair, this and that, all these things. So how can you claim this sort of thing, future care expenses? And what about fatal accident? If that person die, okay, then the wife wanted to claim, just now what I give you an example, the dependency claim. So these are the things that we'll be looking at in next week or so. But today, we just focus on this area. So there is a list of cases. So we take a break and I will go through these cases, okay? And I'll tell you where to read, what to read, is it important, what you're going to do with it. All right. Now, there are also, if you see on top of here, there are some web link I'll send to you. So I'll send it to you during the break. Okay. So we take a short 10 minutes break and then we'll come back and do the liability. Right, let's continue. Now, in liability, this is what we're looking at. So I actually explain it to all of you already. General principles. Now, the general principles is the one that we always look at. It is the same thing like how we you studied for thoughts in LLB days. But there is one thing I wanted to mention here. Same thing like contract. We, like I said, we are not so much concerned with what is contract, offer, acceptance, consideration. Same thing in tort, because if you look at tort, that is of course is a breach of duty. There's a duty of care. There's a breach of duty. There is a standard of care. There's remoteness. Don't spend too much time writing what is duty of care, what is breach of duty. You do still need to write about it, but not so much. This is the part where you need to find the balance. If you write a little bit too much, what is too much to me? Not more than, okay, because one, it is not so much about the principle. It is about how that principle relate to the question that you are they're asking. So just by saying, oh, the breach, there is in tort, this is there is a duty of care. Duty of care is this. Okay, you explain 1.5 page on this sort of thing, then only start to relate. No, you must learn to be able to explain the principle at the same time relate it back to the question. It takes skills and practice. Because normally what we would do is we explain the principle first, then after that one paragraph relate. You can do so as well. But another thing, for exam purposes, time management is another issue. So you need to learn. This is something where I keep saying to you, I'll show you where the door is, but I need you to go and open up the door. So today is one of them. So I'll tell you what to read, but I want you to come up with your own way of writing. The principles are the same. There's nothing too difficult. But how do you structure the sentence? Because if I write it out and give it to you, the answer is me writing, not you. In an exam, you need to practice. You are the one that need to write the answer. Okay, so you need to what do you call it? Structure the sentence, train your thought process. So you need to write about principles when we look at questions. We look at questions in an exam. I'll pass a question, you will know more. But try not to write more than a page on this area. I think probably half a page on the general principles, and then relate it another. Okay, what? So the total 2A questions sometimes is 15 marks, sometimes that. Try not to be more than a page, including the principles, things like that. It depends on the time. Okay, it very depends on the time. So when we practice, we see how. So motor vehicle, the principles under motor vehicle, it's the same in general principles. Rylance fracture a little bit different. Okay, it's not examined. I don't expect it to be in your question as well. So, but just know the concept from your study manual. Nuisance, yes, there are private and public nuisance. Occupiers liability and vicarious liability, they are normally not on its own, but together with like general principles, okay, or motor vehicle, combine them together. And then we have professional negligence, in particular medical. So there are areas like solicitor negligence. I don't think you have a question in there, but that case, that sort of explanation is good to support our articulation in your professional practice paper. Now let's look at the general principles, okay, of your negligence. Now, in general principles, it always start off, there is a duty of care. Once there is a duty of care, then the next step, there will be a breach. Okay, if there's a breach, then you will need to look at, is there a causation? Is it too remote? Okay, the person that owe you that duty of care, is it too far away? There is a remote, the neighborhood principle. Then we look at what is the standard of care. It is general, okay? It is fixed, this sort of area. Not from the UK law, not only from the UK side, but also from our Malaysian law. But how do you structure it? How do you write it up? This need practice, and everyone is different. So I want you to practice on this one. You can start writing up now, come up with 1 page, 2 page of that one. When you start doing partial question, then you, what do you call that? Compress, okay? Up until where you feel that, oh, the way you write it is so smooth. Okay, don't leave it. This is the problem. You student in CLP, if you don't do enough practice, you won't write well. Imagine this. You imagine this scenario. You read duty of care, breach of duty, Standard of care. You know it is in here. But when you write it up in exam, you got stuck here and there. Because you will not you know how to read in here, but you do not know how to write it out. So the practice, the focus must be output writing from here to here. Okay, from here to here. So this is what you need to practice. So the more you write, the more it will flow naturally to you. This is where I said I'll show you where the door is, but I want you to go and open up the door. You need to write. I could write the ad for you, but that's me writing. And you will end up still reading it, read. And when you go to an exam, you're still stuck. So you must practice on writing. That's why we do a lot of past question. Now, look at the notes I give you. Here. So we talk about preliminary already. So when we look at past question, we'll see some of the questions we need to make sure that we got a courts, limitation parties. So what is it? In tort general principles, you always have a duty of care. You always have a breach of duty. Okay? Then, what is the standard of proof on the balance of probability? We learn more about this standard of proof when it comes to evidence. So you just need to know is balance of probability. So there is also another one, causation or remoteness. Is it too remote? You can write it there. What about standard of care? As a general rule, the standard of care is of a reasonable meant. But there are also other areas which may be different. For example, medical negligence. Is there any contributory negligence? This is the general 2A answer. The flow is like this. And depending on the question, is it motor vehicle? So the motor vehicle, the principle is still also the same. This one. If it's like nuisance, then it's a bit different. If it's like professional negligence, then your standard of care is a bit different. But general, your principles applicable for most of them. Apart from nuisance, then maybe a little bit different. Okay, so we'll look at that when we do past the question. So this is the general flow. Most of the answer, most of the question, you will go by this flow of 2A. Apart from nuisance, medical negligence is slightly a bit different. Now, this is the part where I need to, how much do you need to write for this? Like I said, you cannot just explain the duty of care, Donald Stevenson, the breach of duty, write one page, yet you didn't link it back to the question. You can have half a page writing about the principles, half a page on the facts of the question. What is it about? You can do that. Or you may be able to practice, you can explain the principle and relate the facts to the question at the same time. So you see that two ways of writing up the answer. Either way would do. Whichever way that suits you, whichever way that you find it is much better for your articulation. This is the part I want you to practice. You know this is the answer. You know it is like this. But if you end up just memorizing it, breach of duty, or standard of care, you will still memorizing it. You will stuck when you write the answer. So that's why I keep telling all of you, the way to pass your CLP must be by output. You must do a lot of output. So we don't need a lot of lectures, but we need a lot of practice. So this is, even now, after this class, this weekend, when you look at the lectures, you can start to write up, okay, in this area. Okay, in duty of care, how can I explain this? Just write up as a general principle. Maybe you end up writing 2 pages. Never mind. Okay, keep that notes. When we start doing question out of the 2 pages, then you compress again. Oh, maybe now I can write faster in this area. Not just faster. I think this sentence is, it doesn't, there's another thing I said, not just in exam. To me, how do you say that? More, it doesn't mean good. Having more doesn't mean good. Okay, to me, less is much better. There's an English word for it, but I couldn't think about it. It's whereby if you can explain something using 1 word, it's much better to do that than using 2-3 sentences. So again, it comes down to your language, your vocab, your grammar. It all adds up. So you can make a notes now in this area. On this, you know it is here. You studied for this in LLB. 2 pages. When we start doing past question, you compress it. Oh, you feel that this sentence that you wrote doesn't support it, doesn't have any point. Cut out this sentence. Hey, I can combine this case and explain this fact together. Okay, much better. Then the more you write, the more it compress until it comes to a point where you feel that, okay, this is it. This is the best way I can write the duty of care. So this is actually, you can actually prepare the answer beforehand already. So You know it's like this. And if it's motor vehicle, then you just apply the facts back to it. Of course, if it's medical negligence, nuisance, you need to make some amendment here and there, But you can actually know the question 2A is about this. You can actually prepare. Prepare not by memorizing, prepare by writing the questions, okay? Answering right up, okay? Now, I give you this case here called Arab Malaysia Finance and Stephen Poor. There are many cases in this area. Now, of course, if you look at, where is it now? Wait a minute. If you look at your study manual, there are also areas in this. You can use it the right up, but there are many cases. There are no you can read, but I wanted you to read this Arab Malaysian Finance. Okay, before we go, that if you look at your study manuals, all right, there are areas in this that talk about duty of care, breach of duty. You can use all that. Okay, you can use all that. But I give you this case of Arab Malaysian Finance and Stephen Poor because they also talk about some of the duty of care. So I want you to learn when you read this kind of cases. Now you need to start reading cases. Okay, sometimes some of the cases, who's the judge in here? Gopal Sriram. Okay, how did he structure that sentence? Use the language that he uses so that your answer can be much nicer to read. Because if English, I just was chatting with my friend that day, and I was asking her, okay, hey, we have a group chat. I said, hey, if someone asks you what's your first language, how will you say? I really don't know. If you say, is English is my first language, definitely no. Because I don't speak English at home. My parents don't speak well English. And of course, since young, I'm in the Sekolah Kebangsaan, okay? We learn English, but we don't, if you ask me, is my English that, tip-top? Not really. Some of the words I don't understand, I need to check the dictionary. Then if you ask me, is Chinese my first language? I wouldn't say so too, because I know Chinese, but I'm not from any Sekolah Jenis Kebangsaan. I'm from Sekolah Kebangsaan. I can read, I can write, because I used to go for sort of Chinese. In my place, we have this sort of Chinese school at night. Okay, we call it Ye Xiao. Okay, Chinese school at night. We study for 6 years as if it is same like Chinese Chinese school syllabus. But if you ask me to write Chinese word now, I cannot, because I haven't been writing for so long. I use Hanyu Pinyin all the time. So if you ask me, is Chinese my first language? I would say no. So I don't know what's my first language. I don't know if you all have this problem as well. So if English is not our first language, then to write up something, because always we've said, on the facts, it was stated based on this case, pursuant to the case. Imagine the examiner reading that kind of answer for thousands, everyone using the board. But if the answers start to be a little bit different, the way you structure the sentence, okay, you use the different kind of language. You see this case, I want you to read this claim in negligence. You can read, you see how they use the language. To make out a case of defendant in the tort negligence, plaintiff must establish 4 ingredients. First, he must show that he was owed a duty. Second, there is a tendency on part of textbook writer to treat each of these elements in watertight compartments. Now you see that language. Even if you read also, you feel that, wow, correct? I want you to learn that language, not only just for exam purposes. Because when you are a lawyer next time, you draft statement of claim. That is what I say. If you can use a word to explain it, use it rather than 3-4 sentences to explain the meaning. And it all boils down, okay, to your mastering skill of language. Language is very important. I have students come to me before asking me this. He said, Dennis, I am a Chinese school student. My English is not that good. Do you think I can pass the exam? Now, I said this to them. I said, okay, whether you are mainly a Malay school student or English, because English definitely not always is our first language, whether you're Chinese school, Malay school, whatever, you will pass. But to get like E, a D, C, B, then it's a bit hard. Now, maybe you say it doesn't matter, I just want to pass the exam. Yes, it's fine. But when it comes to practical scenario in practice, you'll find you will still have problem. Because why? Right? First thing, you need to communicate with your client. Second thing, you need to reply email. Third, you need to draft statement of claim. Fourth, what if you are in a commercial area, you start to draft contract? The language is utmost important. Fifth, what if you be a litigation lawyer in civil and you speak even the judge don't understand your language? That will be a little bit problem. Speaking skill, your public speaking skill. I really, really hope I can train and teach you more on this speaking, communication, public skills, public speaking. I'll try to see if I can incorporate a little bit in my podcasts and also in the class to, when I talk to you on one-to-one basis to, train your thought process, how to organize your thought process when you wanted to present something. How do you start first? Okay, rather than here touch a bit, there touch a bit, then end up don't know what you're talking about. Okay, I'll try to teach more of you in other areas on this one. So learn to use this language. You see how they use the language? Okay, so of course they quoted some English cases, Lord Denning. Okay, you see that. Then they uses Donahue Stevenson, Lord Atkin. Now we also sometimes you see it called Atkinian test here. Why? Because this neighborhood principle was developed by Lord Atkin. That is why they call it Atkinian test. Now there is no need for me to go into, because all of you are adult. You study all this thought before. Standard of care. Duty of care. Okay. What is it? Then next you have the breach. Then what is it? The causation, the remoteness, and the standard of care. It's all something that you have learned in thoroughly. In year 2 of your LLB. But I want you to read it up until here. If you can read, up until here, up until the remoteness part lah. Okay, no need to read 47 point onwards. Up until 46, enough. Learn the language, how they structure the sentence, how the judge actually Gopal Sriram, because they are judge, their language is so good. How they talk about breach. What case did you use? You can use all these cases. It's usable. The UK is the same because it comes from the UK. Summarize it in your own words. And okay, if you don't want to do, you just want to read also can. But I want you to learn to use the language. What is duty of care? How do you talk about Donahue Stevenson? Because as normal student, we will say, based on the case, pursuant to the case, as per the case, as per the UK case, okay, the neighborhood principle was enunciated, okay, or you can come up with different way. You see, our courts have traditionally applied the Atkinian test to determine whether in given circumstances a duty was owed by the particular defendant to a particular plaintiff. Atkinian test was enunciated or comes about, derived, okay, from the speech of Lord Atkin in Donahue Stevenson. And in his speech, he came about with the term of neighborhood principle, whereby you need to watch out and take care of your neighbor. You see how I just explained it compared to, it was stated in the case of Donahue Stevenson, as per the case, how it makes a difference in your answer. I'm training you not just for exam answer, but as a future lawyer, how you speak, how in the words that you use, it feels powerful. Sometimes when you speak to a client, okay, it is not so, you see, don't be a robot. When you speak to someone, put some emotions into it. There must be some humanity, the human connection. I always talk about this because I studied medical field for very long, and I was involved in the business for very long, even until now also, yes. So I taught a lot of these things. So this week also I'll be releasing another podcast. The topic of the podcast will be called Unlearning is More Important Than Learning. Okay. And maybe it feels that unlearning, what is it? Go and listen to it. I speak about some other things, maybe no lecturer would talk to you about that. So I want you to learn more than what just in CLP studies itself. So when you speak to a client, sometimes it's not so much about what to speak, but that confidence, that power you can give him, you make him calm down. That's why I feel strange why communication skill is not a subject that you need to study. Because sometimes, like a patient in medical, he just wants some assurance. In law, he gets sued by someone else. He was worried, okay, dependency claim, whatever. He wants some assurance from you because You are someone he look up upon because you can help him. He doesn't know law. He's now being sued for whatever negligence. Then you say, when you speak to him, give some power in your language and speech. Rest assured, don't worry. Okay. Then he feel like, okay, at least you know at the end of the day, this client goes away. He is in a much better condition. Okay, that is our goal. So use the language. Learn to use this kind of language. Now we come across this case of Wu Xiu Ying. Okay, I won't read one by one because you know what is it about. Unless I think it is a bit difficult, I'll go through it with you. But I want you to read this case so that you learn how to use the language in here. Okay, so what I want you to do is this. This you know for sure. This is fixed. Okay, now we'll come across contributory negligence in section 12 when we look at questions. So, for example, this plaintiff was running across the road and get knocked down by the defendant. So he sued the defendant for motor vehicle. But the defendant said this plaintiff suddenly dashed across the road. So obviously there's some sort of contributory negligence, section 12. Or the questions say, okay, it is 1 a.m. midnight. So the plaintiff looked left, looked right, no car. Even though there is a pedestrian bridge 500 meters down the road, he didn't use the pedestrian bridge. He ran across the road after looking left and right, no car. When he was crossing, suddenly a car come and knock him down. So now the plaintiff is suing the defendant for motor vehicle injury. But the defendant say, hey, you should be using the pedestrian bridge 100 meters. So there is some sort of contributory. But is there anything you can fight and argue if you are advising a plaintiff? Yes, there is. I will fight on what a reasonable man will do. It is 1 a.m. in the morning. You know there is no car. You already checked left and right. Do you think you as a reasonable, normal person will go and walk to the pedestrian bridge, or would you cross the road straight away? Always think one step further and deeper. Always, this is what your motto. Okay? Something you're learning from today. Always think one step further, one step deeper. Don't take it as it is. Don't take it. The most dangerous thing is be in your comfortable zone. Okay, always think further. Is there anything you can fight on? Go further, go further, go further. As a reasonable man, do you 1 a.m. would you cross the bridge? Or would you just look left and right, no car will cross the road? So can you argue on that and say that it's a normal person would do so that the judge would not apportion the liability? Yes, something you can look on. Okay, so we look at that when we look at the questions. So I want you to look at the case, look at your study manual. You can, for your work today, you can come out with like 1-2 pages of this area. If you don't want, you have a little bit lazy, then you can I will read it when we do pass the question, only I start practicing, up to you. But the thing I say to you, you need practice. That's it, okay? You need practice. Now, let's look at a few other areas, okay, of this thing. Now, is that really, really important to all these cases that I really, really need to read? Not really. But the cases here, okay, is to illustrate. Again, I want you to learn to use the language. Because these are cases much more interesting, like the duties of counsel, professional practice, all this very boring. Today, much more interesting. You'll find that these are some interesting cases. Now, I gave you a little bit more cases in this area to read is this. Probably 90% or 99% of you in this class, when you graduate, you will be in the civil areas because first, money is fast. Not a lot of you wanted to go in the criminal. And most of you will go, definitely, if you're in a civil, you come across this motor vehicle insurance claim, this sort of thing. So it is something to train you for your future career. So you see how, when you read the cases, especially you see these kind of cases like Zulsafari, Mohammad Sharil, how the court go one step further and think deeper? Because you see that as a normal person, you won't think so far. You would think, if it's 1 + 1 = 2. You see in this kind of cases, 1 + 1 is not always equals to 2. They go deeper, deeper, deeper. How you can read between the lines, the isi tersirat. So out of this, if you ask me, what are the really, really important case you wanted to know? I will say this. Ao Kien Ho, I want you to read. Siri Inai, you must. Fu Fiona, okay? Stanley Isaac, Nyo Aye, and this Zuhasnima, Dr. Kupu. Okay, these are the very important one. Others, if you tell me, Dennis, I'm a little bit lazy, I want to go out. Okay, then go out. All right. But if you can, please. Okay. But I can tell you where to read. Now, let's look at one by one. Okay. So the rest of the lecture, we look at, just go through briefly. There's nothing too hard. I'll just briefly explain what the case is about, and then you can read it on your own. Now, Zusafari. It is a motor vehicle, not motor vehicular. Okay, motor vehicle negligence. Now, there is nothing too difficult to it, but I want you to read the case so that you see how the judge come out with this is what you'll be expecting in your exam question. They have a scenario, so you need to deduce from what happened in there. So I want you to learn to get a feel of the case law. Okay, how did the judge go and decide how much to give this sort of damages? All right. Okay, this thing, closed fracture. How did the judge come about? Because you need to look at what did the judge think. How did the judge think? How did the judge look at it so you can prepare, not just in exam in future. Okay, this is where we attack. This is where we defend. This is where we have ability reserve. So this is how did the judge come about looking at how much to claim. Okay, complete paraplegia. So all these things. Now, of course, it's not very important cases, but the purpose I leave it here for you is I want you to look at, you see, how did the judge look at it? Whether there was a failure to consider. All right. What did the judge think? Investigation officer's evidence, so that you get a feel for a proper case. Okay, so that you get a feel how did the judge, okay, whether extremely high standard of care, whether learned trial was wrong and draw an adverse inference. So look at this. Okay, there's nothing too much. Now for this class today, there is no, like as been before, I wanted to make sure I mention this every class so that you all know what to do. There is no need to memorize. Okay, again, no need to memorize. But if you can, please do a notes in this area or based on the summary, okay, start practicing. If you tell me I'm a little bit lazy, can I do during past question tutorial? Yes, you can. But if you can, try to do it now. Like I said, I'll come to you all this weekend and text you and see how you're doing. Consistency is key. Okay, to me, it is much better if you do something every week rather than kumpo everything and then one shot study 2-3 days you didn't sleep. No, consistency is key. Right? Now, for all these cases, do I need to memorize anything? The answer is no. But I want you to read the web link that I give you in the class, which I also put in the YouTube, okay? Like nuisance, whatever. But there is something that in particular you must know is the standard of care of medical negligence. Okay, and also what are the factors for nuisance? And also, if you study manual, okay, in occupiers liability, all right, in your study manual, you can open up your study manual in occupiers. They have a 4 type of entrant. I find it was very well written on that area. You need to know that 4 type of entrant. Okay, if you tell me which particular area I must definitely keep in mind, number 1, I think this one you know. You don't have to keep in mind. Already know. Okay, I will say this is number 1. Number 2, nuisance. What are the factors? You can look at here. All right. We'll talk about it later on. Number 3, the 4 type of entrant. Occupiers liability. Number 4, this in particular, Zuhanis, Nima Hassan and Dr. Kupu, and also the web link I can give you on this area. What is the standard of care in medical negligence? I also make a podcast about this. So, as usual, I will link the podcast in the YouTube video so that you can listen to it at the same time. Okay? Now, of course, I give you other website on this area. Okay? Now, I don't think I need to go into too much. I'll just briefly touch on it, and then when we do pass the question, we'll talk more about this area. Now, for Zusafari, I want you to read the case. Mohammad Sharil, I want you to read the help part. This is a very interesting one. Where is it? Now, what happened in this is this. This is why I want you to read this help part, because I want you to go into deep further. You see how we look in between the lines. So what happened on this is this. This guy, okay, what is it? I cannot remember who is the plaintiff and defendant. So basically, the plaintiff, okay, knocked the defendant down in a motor vehicle claim. So the defendant, sorry, not plaintiff, sorry. The plaintiff now is suing the defendant because the defendant knocked him in a motor vehicle causing injury. Okay, so plaintiff is suing defendant. So defendant argued that plaintiff has contributory negligence because plaintiff is driving without a license. Section 12, contribute. Now, just up until here, plaintiff sued defendant because defendant knocked him down on motor vehicle. So plaintiff wanted to claim medical expenses away from defendant. Defendant argued plaintiff should be liable as well because plaintiff has no driving license. If just by the story up until here, would you say the plaintiff is liable or not liable? I mean, not liable. Would you say the court should also make plaintiff liable for certain portion because he contributed to it? You drive without license. If just by up until here, the answer is yes. But you can see how the court dig deeper, look into the facts, differentiate the facts, look deeper. In this case, the plaintiff, they stay in a kampong. And the plaintiff has been driving without a license for 15 years or so, 12 years or so. And he never involved in any accident. Yes, he was driving without license. He violated certain law, he should be summoned procedural-wise, he's wrong. But driving without license doesn't mean he drive carelessly. Driving without license doesn't mean he drive in negligent way. Yes, he didn't go through a proper training and exam, but he has been driving for 12, 15 years without a single accident, and his skill without license is as good as you and me, which have license. So the court say even without him, without a license, okay, doesn't mean that he drive negligently or dangerously. Yes, on statute-wise, he should be summoned, but that's how you see how the court look at it differently, how the court go deeper into it rather than, oh, no license, contribute. Because I think as usual, no license, we say contribute. But you see how the court go further, look at the facts, look deeper into it. So I want you to learn this skill, not just in exam, but in future endeavor. When you look at your cases, look at your clients, can we go deeper? Always ask yourself, can we do much better? Can we do better things to improve? Can we go further? Can we go one layer down? So see how. So I want you to read this help part, so interesting. So you see how the court, okay, failure driving license ought to be not amount. Maybe not something that you think about. Okay, read this one. Next one. Washan Development and Success Portfolio. Now, if you look at Rylance and Fletcher in your study manual, what is it about in your Rylance and Fletcher? There's something escaped, okay? Okay, dangerous. So normally, it's like animal. Okay, by right, if I give you an extreme example, this neighbor keep a tiger in his garden. By right, you shouldn't keep a tiger in his garden. And then he keep a tiger in his garden, and then the fence is very low. So the tiger jump over the fence and come and bite you. So now something dangerous, illegal use of the land, escape. So I don't think you will get a Rylance Fletcher question. Okay, I haven't seen a question. So that is much more a Rylance Fletcher. There is an escape. Okay, so if you Google Rylance and Fletcher, there's everything in there. All right, so in your study manual, whatever that is stated in there is also good enough. Oops, sorry. Okay, Rylance and Fletcher. All right, all these sort of things. The same in tort law. You can see the rules. What are the things? Rylance and Fletcher. All right. Defendant brings onto his land a non-natural use tiger. Okay. Sometimes is what? Sometimes in your garden you keep you rear, let's say you rear ducks in your house, and because you need to rear ducks, you need to build a big pond. Okay, so by right, the house can only be a house, it cannot be a pond. And then something break loose, the water from the pond flow over to a neighbor house, causing your neighbor's house all damages. Then Rylance and Fletcher first, because you bring into a land a non-natural use. You have a tiger there, you have a pond there, something likely to do mischief, it is escape. Okay, what is escape? It can water. Okay, if it break, it will come and cause flash flood. Sometimes what else? Okay, fire. What about? Okay, your neighbor. He's a kalanguni. He keep a lot of rubbish in his house, and then fire escape happen. Or he keep a lot of gas stong in his house. You know those people have a lot, thousands, hundreds of gas stong in front of their car porch, and then what if explode? Fire. Okay, if it does escape, the defendant is prima facie liable for damage, natural consequences. The escape thing is like the animal escape, the fire. Normally it's fire, water, okay, animal, okay, this sort of thing escapes, and then it does. It doesn't stop at just escape. When escape, what is it? It must have caused damage to you, personal injury, to your property. Then only you can sue. If it escape, it doesn't cause damage to you, then you cannot sue. No damage, what to sue, right? So it must be non-natural use, mischief, it escape, fire, water, animal. What else I can think of? What things can escape? Gas, okay, gas like poison gas, all right, okay, gas stong and explode, this kind of thing that can escape, okay, this sort of thing. I don't think you have this area, Bryden's Fletcher, but this case is also on a private nuisance. Okay, let's see, Vashan. Again, you will understand, so I don't have to go through the whole thing. So this case is where about there is land beside, okay, land beside. So I'll give it to you the facts. Then after that you can read the case on your own. All right. The plaintiff is a property developer and the defendant is pig, rare pig. So the rare pig, because if you rare pig, they have the smell. So the plaintiff developed into a mixed development of all these sort of things. Then the plaintiff institute action in private nuisance. Nuisance, what is it? Okay, now once we talk about nuisance, then I talk about nuisance. Nuisance, I want you to read this article. There are two categories, private nuisance and public nuisance. As the word suggests, one is private and one is public. So let's look at what is private. For a plaintiff to successfully establish an action under tort of private nuisance against a defendant, he will have to prove that there is an interference with the enjoyment of his property, that such interference was unreasonable, and that the interference can cause him damage. Now you see, just now I said you need to know about breach of duty, standard of care. That is much more to a principle of negligence under motor vehicle, vicarious, medical negligence. But if it's under nuisance, it's slightly different. This is the factors you need. Okay? That there is an interference with enjoyment, that interference was unreasonable, that the interference has causing damage. What about if it's a public nuisance? Public means it's interfere with the use of public properties. You are driving on the road, suddenly a tree fall down and crashes on the car. So you sue the DBKL for public nuisance because DBKL know the tree is dying, but why they didn't go and cut down the tree? So now it crashes on the public property while you're driving is a public road. If it's a private, meaning you walk in your garden, suddenly, okay, your neighbor plant a durian tree, become very big, and the durian come over to your house and the durian fall on top of your head, cause injury. So why didn't your neighbor do something? Private nuisance, okay? Interference with the enjoyment. Because now you in your property, walking in your garden also, you don't feel safe anymore. In such interference was unreasonable and interference caused him damage. So we look at the factors and the case and also the question. There are cases in this area. So I want you to read this article. And this is the case Ao Kian Ho, which I also give you as well. And I'll talk about this as well. Okay, later on. Ao Kian Ho. Okay, post Ao Kian Ho. I want you to read this article. Very good. This is not what else. This is a duty of care. You also sometimes see this case of Batu Kemas. This is a TNB where they were doing some digging on the road for some fixing on some electrical thing, then accidentally destroyed some of the electrical wiring, causing the whole industry area in Batu Kemas no electric for don't know few days or whatever. So they lost a lot of money. So now they sue TNB for tort of negligence. So I want to read that. Okay, I think electrical lines. Okay, government. Okay, disrupted. So you can use this one. You can use Stephen Poachinchu. Okay. You can use the study manual or any other article also can, because the law is the same. Okay, I want you to read this one. Now coming back to the notes. So this one, the plaintiff instituted private, now you know what is private enjoyment against the defendant, alleging that the smell had adversely affected the plaintiff's sale. Okay, so that's why I say this is also classified under Rylance and Fletcher, because it also can be Rylance and Fletcher. And so to do that, the land by right should be a housing area. Then he go and rear pig, and then that thing escape. What can escape? Smell. Smell escape can be smelled. Okay, plaintiff prayed for injunction, restraint from continuing. Okay, as well as general damages. So general damages need to be assessed by the court. The defendant argued that the smell was minimal and claimed that it was licensed. High Court dismissed the plaintiff claim. Plaintiff appealed to Court of Appeal, where the grounds are followed. The trial judge is wrong in a failure to consider the use of the lands. Okay, a failure to appreciate the defendant being earlier in time using their land as a pig farm did not give the defendant any rights to create private nuisance. What he was saying that the trial judge, the High Court judge says, oh, the pig farm was there first. So now you as a developer, you go beside the pig farm, you should know the pig farm was there, then you shouldn't buy the land and build the house there. Then they argue to the Court of Appeal and say, what ridiculous decision is that? Just because the pig farm is there, I cannot go there. Is the pig farm should make sure that the smell doesn't come out and disturb other people. Okay, so this is what we call the eggshell skull rule. I think. What is it? Is there anything I can see? Now, eggshell skull rule. Okay, eggshell skull rule. Then number 3, the approval by relevant authorities. Okay, number 4, what is it about? So now he wanted to sue and stop this person, okay, from using the land, okay, because the smell is coming over and disturb his property. He cannot sell the property. So I want you to read it, how it come about with this decision. Okay, you see the eggshell skull rule, okay, the smell of the pig farm, okay, all this sort of thing, nuisance. This is much more on private nuisance. Now again, this is not like a particular landmark question, but I want you to read it so that it gives you an idea how did the judge come about with this decision. Okay, you don't have to make notes also can, no problem. But for the one I want you to read notes is Arab Malaysian Finance, okay. Ao Kian Ho, I want you to. Now, Ao Kian Ho is also private nuisance. You can look at this one. Not this one. This one, Ao Kian Ho. Or you can look at here. So, Ao Kian Ho is one. And now, if you all stay in KL, certain areas, especially like USJ, okay, you know all this USJ 1, 2, 3, 4, 5. All the taman, they have this boom gate, BOOM. It's like you go in and the private guard will, let up the boom gate and then your car go in and then pull down again. So for security purpose, because at that time, many years ago, the security was not that good. Now, a lot of this boom gate in USJ, they all got approval already from the Majlis Perbandaran. Some may be illegal, but some definitely they have approval. So what happened was this Ao Kian Ho, he used to be a management committee in this area. Okay, he used to be a management resident in secured. When they moved into the estate, 2 boom gates and security guard house were already in place. Residents, of course, pay monthly. So, as usual, you need the boom gate security guard, you need to pay monthly. Sometimes, in July, residents agreed that those who refuse would not enjoy the facility provided. So, what happened is you didn't pay monthly. So, what happened is you still need to use the road to go in, right? So, the guard will not open up the gate for you. So, you need to go there, open up the gate yourself, drive in and pull the gate down because you didn't pay, right? Right. So the appellant, okay, this is Ao Kian Ho. They actually joined the resident association and become the treasurer. And during this period, he didn't raise any objection. Then after that, he left. He was not a member. Then after that, he didn't pay maintenance fee. And because he didn't pay maintenance fee, whenever time he go home, then the security guard won't let the boom gate up. So he need to get down of the car, boom gate. So he's annoyed. So he sued this Persatuan Penduduk that says that, hello, you management committee, you built a boom gate there causing private nuisance to me. What is it? What private nuisance are we talking about here? Interference with my property. I cannot go back home. Unreasonable. I need to stop car, pull out, pull down, and it costs me damages. Okay, he argued that. But the court says no, you cannot get back the money. I mean, you cannot sue for private nuisance. First thing first, the boom gate was approved by the Majlis Perbandaran. There was a license. So it was not built there out of illegal. Second, the boom gate there is to provide security, all right, for the residents in that area. They said that, okay? You see, the appellant therefore sued nuisance. So I want to read dismissed appeal, meaning no point of appealing. Because first thing, they have license. Second is to protect them for residents for security. So I want you to read how did the judge come out. Now, you can read this case or you can read the help part and then you can read this article. They talk about it as well. Okay, Ao Kian Ho, you see the decision in a nutshell. What is it about? Okay, what post Ao Kian Ho is it? So this is the one I want you to know. This is a landmark case. All right, not really a landmark case, but interesting, very important case. So I think there was a year, I think 2022, there was a question in regard to boom gate as well. So in the answer, I touch a bit about this Ao Kian Ho case. All right, now next. Hot Wheel Nursery. This is Hot Wheel Nursery, again, private nuisance. You can say it is Rylands and Fletcher as well. So this is plaintiff, he's planting orchids, okay, in the piece of land, all right? But he's suing cause loss and damages caused by flood water from adjoining defendant land, okay? You see, plaintiff has do the planting orchid. Defendant was developing into a land. So, you know, when they do development, they need to make sure the water flow, everything is okay. When this guy defendant, he do development, he didn't correct the longkang properly, cause the water to accumulate, stuck, then overflow. When it overflow, it come down to his orchid farm and destroy all his orchids. So you can say this is Ryland Fletcher. You can say this is a private nuisance as well. Okay, this is a private matter. So same thing, I want you to read this case to appreciate how did the judge come about. You see the law or negligence, whether a duty. So it's the same thing, Daniel Hill Stevenson. Atkinian, again, use this language, how they come about. All right. So what is it about? It is still on negligence. Okay, it is not different from negligence. It is still, you still owe a duty of care. There is a breach of duty. You still need to talk about negligence. When we look at the answer, we see how we talk about it. Okay, you can talk about negligence, but on top of this negligence, for nuisance, they have to be a little bit different. You have this improper effect, enjoyment of property, cause damage. Okay, this kind of extra under the private nuisance here. All right. So it is still the same thing. There is still some damages, okay, loss, breach of duty, neighborhood principle. It's still all the same. It is all the same. It is just on top of nuisance, you need to be a little bit different. Okay, same thing with your medical negligence. We'll see that how we answer the question. Now, next. Now, I want you to read this case of Siri Inai. And I also make a podcast about this. Occupier's liability. What is occupier's liability? And you need to know the 4 types of entrant. So for example, today you went to Mid Valley for shopping and the cleaner is mopping the floor there. And because the floor is so wet, you fall down and hurt your backbone. So now you need a surgery, whatever. So now you sue the mall for tort of negligence. So then, are you a contractual entry? Are you an invitee? Are you a trespasser? Are you a licensee? So I want you to know these 4 types of entry. You are most likely an invitees. Okay, you go there for shopping. Okay, invitee. So you need to know these 4 kind of different entrants for people. Now in this Siri Inai case, it's a very famous case. And there was a question in 2018 or 19 that sat solely around this case. But in your exam question, but the facts are different. So when we answer the question, the answer I give also very different. Okay, depending. So it doesn't mean, it doesn't mean that if the question based on this case, you must die follow. Sometimes an exam, the question is, you can know the question is set around this case, but the facts of that question is different from the case. And then your understanding, your analysis has to be different. So again, don't twist it just to fit into your agenda. Based on the fact, take it as it is. What are the facts saying? Now in this Siri Inai, this is the case. I want you to read the whole case. The issue was this one. Does a landlord owe a duty of care to his tenant's lawful visitor? So, for example, now you rented a house, okay? You rented a house, and the house is not new, it's a bit old. So, there are certain areas in the house is not that new. But your landlord didn't do anything, even though maybe you have told him. So now your friend come and visit you. Your friend come and visit, wow, Dennis, you moved house. Yeah, I said I rented this new unit. And then my friend go to the toilet. When he was in the toilet, suddenly that on the ceiling fall down and crash on him. So now, this my friend, he maybe will sue me. He maybe wouldn't sue me because me and him are friends. But he would like to sue the landlord of my house because my landlord didn't take a proper care of this unit before he rent it out. Can he do so? You may think about, wow, it's a little bit far. Is there a privity of contract? Because what happened was, this my friend and me are friends. My friend and the landlord is a little bit far. Privity of contract. So this is the thing. I want you to read this case. This case was this. There was this building in Penang, rented from the Majlis Perbandaran, Majlis Bandaraya or whatever, MB, Penang Council. The Penang Council owned the building. The building is like a Second World War leftover building, very old. And the person that renting them wanted to use that building as a school. So of course, school, there will be children in there. So one day, okay, it was rented and become a school, whatever. One day, a fire happened in the school. And 10 or 18 kids died. This is a very old case in 1988, if I'm not wrong. Okay, 1989. Okay, young children die because they wanted to run away from the fire escape. I think the fire escape door was locked, and then the fire escape staircase was broken. So now the parents of these young children sue the school as you didn't provide proper care, negligence. They also sue the Majlis Perbandaran who own the building under occupier's liability. Okay, that they should make sure that the building is in good condition. But the Majlis Perbandaran argued that, yes, I do own the building, but I have no privity of contract between me and the school children and you. I don't take care of, I don't manage the building from day to day. I'm just the owner. I rent it out to the tenant. The tenant, which is the school, Siri Inai, should be the one that take care. So the issue was, should the Majlis Perbandaran be liable? The answer is yes. They should. This is a legal principle. And I want you to look at the reasoning why. Why they said the Majlis Perbandaran should be liable. This is your homework for today. You need to read it. Okay? You need to read it and understand. That is where you learn. Okay, I tell you, this is a landmark case you must read. This is the issue. So, occupier's liability, okay, is the person owning the building, the whatever, that occupy that area. So like Mid-Valley, the occupier. This is occupier. So I want you to read Siri Inai. What about Wu Siu Ying and vicarious liability? Now, let's look at Wu Siu Ying. Now, these ones, you just read the help part is good enough. Okay, just the help part. This is a bit boring in this case. I think if you don't want to read also you can read the help part. I wouldn't go into too much. It's whereby there's a quarry, quarry where they extract to get marbles and the stone fall down and crash on the house or whatever. Okay, this is a bit boring on this case. So you can read that. Now, the next one is this, vicarious liability. Vicarious liability is this. The boss of the person. Now, I want you to make sure you don't confuse. Now, if today you cross the road, you got knocked down by a rapid KL bus, you sue the bus driver for tort of negligence. You can also sue Rapid KL, being the employer of the bus driver, for vicarious liability because he didn't make sure he give proper training to the bus driver. Or maybe the bus driver was drunk on that day when driving the bus. Why? There is no some system in place to make sure every driver, before they start their work on day, they have some sort of alcohol test or whatever. So you sue the bus driver for tort of negligence, then your principle is the same. Breach of duty, duty of care standard. You also sue, the Rapid KL for vicarious liability. Same, because they owe you a duty of care, things like that. So the thing is under a different heading because the issue of privity. By right, the privity of contract is between you and the bus driver because they owe you a duty of care. Now you're trying to extend the duty of care to even the bus driver employer. That is what we call as a vicarious liability. Now take note. It cannot be used. It cannot be used. Let's say you are a technician working for TNB. All right. And you and your supervisor went into an area to fix some electric. And you have to climb up there. Your supervisor didn't do anything, didn't help you put on a safe vest. You are just junior, start work on the second day. And you fall down and injured yourself. You now sue the supervisor, your supervisor, or thought of negligence because he didn't take good care of you. Can you also sue TNB, which is your employer, for vicarious liability? The answer is no. Okay, it doesn't work like that. Because he is your own employer. You sue it under thought of negligence. The contract privity, there is a privity between TNB and you because TNB is your employer. So there is a privity, there is a contract, you sue them. Vicarious is whereby you sue the bus driver. And the bus driver's employee, you see the privity, the distance is far. Because you wanted to extend the duty, you go and sue him under vicarious. You cannot sue your own employer for vicarious. Okay, it doesn't work like that. You just sue him for thought of negligence and that's it. Much easier, faster. You don't sue him for vicarious. GMP Kaisa, if you are from Penang, you know this case. There was this case in 2004, 3-4 years ago. Okay, there's this Dato. He hired a bodyguard and to protect him. Okay, go through the facts. The first defendant, Jafar, was employed by the GMP as a bodyguard and was subsequently placed under the control authority. So this is the employer. Okay, this employer, which had engaged GMP service. Okay, to provide armed personnel guard. So he has gun. 2 days after commencing his employment, Jafar has been equipped with a firearm. So he was tasked to protect Dato' Ong. Okay? Bodyguard to one Dato' Ong. Then, Dato' Ong and Dato' M, okay, they went out together. So, of course, the bodyguard will follow because he protect Dato' Ong. So, Dato' Ong and Dato' M drive. I think Dato' M was the one driving or Dato' Ong is the one driving. And he asked the bodyguard to sit behind the car. Okay? And whilst in the car, suddenly this bodyguard take out the gun and shoot Dato' M in his head and die. After that, Jafar then randomly get down and shot at the members. The respondent, meaning one of the public, was shot when he approached Jafar to find out what happened. So Jafar is the bodyguard hired by this company GMP, and then this Dato' Ong called GMP and said, I need bodyguard to protect me. So one day, Dato' Ong and Dato' M out, and then the Jafar was protecting him. Dato' Ong and Dato' M was driving. Okay, the bodyguard sit at the back. Bodyguard suddenly take out the gun and shoot and kill Dato' M and get down and shoot at other people. High Court in finding favor held that on a balanced probability. So now Amirul suffered one of the public grievous injuries from gunshot and filed a claim damages against Jafar, obviously. Okay, thought of negligence. He also wanted to sue GMP, the employer for Jafar, for vicarious liability. Because the Jafar, I think, was found to have some sort of mental illness, if I'm not wrong. I think it's mental illness, okay? Some mental problem or something like that. You can read the case. So he was saying that why you as a employer didn't do a proper check that this bodyguard is in, good health, can work, and you put him in the work straight away. So you GMP definitely has some sort of liability. But GMP has no direct connection with Amirul. Amirul and Jafar, yes, because Jafar directly shoot him, so there is a negligence. But for Amirul to extend the duty of contract to GMP, then he will use vicarious liability. Okay, that's vicarious liability. Now, let's not take a break. Okay, we'll finish off this because just a little bit more, and then we can finish around 12 like that. In professional negligence, I want you to read Fufiona. I want you to read Zulhasnima Hassan. Okay, I also give you Hari Krishnan. Okay, and I also give you some. This is with regard to Hari Krishnan. In Hari Krishnan, they came about with a different kind of heading to claim damages, what we call as aggravated damages. This one. Meaning, aggravated is something that put you in a bad condition or cause a lot of damages. In Hari Krishna, in this case, the doctor was negligent in his medical practice, causing the eye to go blind for the patient. So because the eye is blind, so it's ugly, so the patient now sue him not only for special damages, general damages, the court also give a compensation under aggravated damages. Okay, it's like he has to live with that scar for the rest of his life. So that blindness. So I want you to read that. We'll come across that when we do questions. Okay, it is very interesting reads. Okay, this is what we call eye. This case is coming we call eye appeal case because of the blindness of this eye. Then the case I want you to read. This is your homework, and I explain briefly to you. I want you to read Fufiona, and also I want you to read for Zuhasnima. For Fufiona, if you can, try to read the whole case. It's a little bit long, but it's a very important landmark cases. Okay, I want you to read Fufiona. This is how many pages? 20 plus. If you're a little bit lazy, then you can read the help part, but please try to read the full case. For this Zuhasnima, I want you to read the help part. Okay, I want to read the help part. What is the standard of care for medical negligence? I also make a podcast about this, which I'll put a link in the YouTube video. The standard of care, you see that every standard of care when it comes to medical negligence, there are always two cases being quoted. These are the UK case and the Australia case. One is Bolam, the Bolam case. Second is Rogers, Australia case of Roger and Whittaker. So, in the beginning, there was only Bolam. Then come Roger and Whittaker. They separated it into two different things. If today you are... Where is it? Before I get confused. Where is it? There's another website. Now they talk about Fufiona. Yeah, okay, here. They separated into two. In terms of diagnosis and treatment, the test we are following is Bolam test. In terms of advising the patients on the risk of the treatment, the test we are following is Roger and Whittaker. Bolam test, what is the standard of the test? Same thing, duty of care, breach of duty. The standard is at a reason, what another reasonable medical doctor would do. So but you need to take note, if today this is under specialist for brain, then you need to ask another reasonable, almost same like another specialist, medical brain specialist would do. You cannot be now, this case is regard to brain damage because the specialist doctor give wrong treatment. You go and ask a general family doctor because the level is different. You need to ask almost a similar person. So Bolam test is based on what another reasonable doctor would do, or what will the group of doctors, what is group of doctors? Just like us, we have bar counsel, you have medical counsel as well. What would the medical counsel? So they will ask the professional people to come and say, in this kind of scenario, what will you do? Then they will compare with, okay, in this case, currently what did the defendant or the doctor do? So whether is it reasonable or not reasonable? So I want you to read it and, maybe you can make a notes on this one. So I also make a podcast about this one. Listen to podcasts, read this article, read Fufiona, read Zuhanisma. Roger and Whittaker say the standard of the breach of duty, okay, with regard to the standard of care given in advising duty, for this one, It is to be decided by the court. So, if let's say the plaintiff sue the doctor, said, you didn't advise me before I do this surgery that there's this risk of I will go blind. Why you didn't say? So then now he's suing the doctor in the court. So what is the test, the standard that the court will look at? The court will follow Roger and Whittaker and say, instead of using Bolam, where they will say what another reasonable man would do, reasonable doctor would do, Roger Whittaker say it is for the court to decide. So the court will set, okay, is it reasonable for the doctor not to mention this risk or not? Or is it okay? Is it not okay? The court will set the standard. The judge is the one that set the standard. Compared to Bolam, the standard is compared with what another reasonable doctor would do. So this is what I want you to know. Okay? You say they talk about Zuhas Nima. Okay? Talk about Hari Krishna. I want you to read this. I want you to read Fufiona. This one, Fufiona. Or is it? Okay? I want you to read Zuhanisma, the help part, and also listen to the podcast. Okay? That is for your medical. You will get questions in medical sometimes. It only come out in your recent paper started in 2022. Then, there's a few more. Now, for Nyonya Aye, I want you to read it. I don't think you will get that question in an exam. But this is an interesting question where he sued the lawyer for solicitor negligence. Okay? So whatever you read in there, Nyonya Aye, it is with regard, you can sue a lawyer for negligence. So it's an interesting case, okay, for your own reading. You don't have to make notes of that. There's also another one. This is the one. TNB and Tetuan Arif, the lawyer, got sued for negligence. So I want you to learn to use the language, how they come about, talk about negligence and immunity. So whatever you learn from there, you can also use it in our professional practice, duties of counsel, solicitor, immunity, and negligence. Okay? Now, there's another case, I think one more, which is this one, Stanley Isaac. Now, Stanley Isaac, you can leave it first. Next week only you read. Because next week, we will do on claim of damages. Can claim, cannot claim. So this is a very good question where you can actually see how did the court decide whether can claim or cannot claim. Stanley Isaac is a famous lawyer. His wife got some sort of problems, went to the government hospital and died. He sued the government hospital for medical negligence. Okay? So he sued it, whatever happens. But this case is not so much that talk about the negligence happened or not happened. The negligence did happen. But it is how the court come about with, they said how much to claim. So this is the liability. You see how they use the word language. Then they started off, you see, this is the part. Finding on damages, special damages. Hospital medical expenses. It was written quite well in this judgment. They separated into very clear heading. Okay, hospital. This is the one I let you claim. Okay, I don't let you claim. No award for this one. Then after that, traveling expenses, because the husband go to the hospital, visit the wife every day. Value of care, funeral. Okay, what section do they use? Expensive memorial. Then traveling, loss of contributions. Then some of them they say cannot claim. Okay, why cannot claim? Why can claim? Then you have, see how they come out with the calculation. Then medical records. General damages, this is the one, it's not special damages. You don't have to plead. It is up to the court to decide. Bereavement, section 7, we'll look at that next week. Maintenance of mother. What about? Then other, you have pain and suffering. Aggravated damages, or this thing. Some of them they don't allow claim. Because these are the things that wanted to claim by Dato Stanley Isaac. Some of them they don't allow. So this is a good question, a good case where you can see how they come about with this kind of claim, can or cannot claim, how they bring about. Others, I think up until here is good. Until 76. Okay? Others are not really important already. Up until 76. You can make a mark there up until 76. So you can read it next week when we do a claim, whether can claim or cannot claim. So these are all the homework for today. Okay? These are all the liabilities. I want you to understand, okay, how to do it. Now, let's make a summary of what we have done today. The summary is, we look at tort overview, what the whole chapter is about, and what kind of exam question you'll be getting. We look at the style, the formats, the different kinds of liability. And most of the time, the important one is you need to know the general principles. And again, I said to you, don't memorize. There's no need to memorize. Write, because you need to practice how to articulate. Okay, you can write it now 2-3 pages, never mind. When you start doing question, compress up until the maybe half a page or 1 page that is good enough, because you need to watch your time. Motor vehicle, very always. Nuisance, private and public. Then you have medical negligence. These are the main areas. Sometimes coupled a little bit here and there, occupiers liability and vicarious liability. Oh, before we go that, okay, while we are doing this, there is also another area in here. This is the one. Now, Occupational Health and Safety Act and Employee Social Security Act. There is this now I just want you to read this article on SOCSO Act, right? Okay, I just briefly explain you this. Every employee pays SOCSO. When you get injured because of some work, you can claim against the SOCSO for insurance. But if you claim against the SOCSO for insurance, you cannot later on go and sue your boss against for negligence. That is what's stated under Section 31. If you can't claim compensation from SOCSO, you cannot later on, okay, that's why I say, bars any other claim for the same employment injury under any written law or common law. You cannot go and claim again for negligence again under thought of negligence. Because why? When you SOCSO, you pay insurance, the boss also pay for you. So in case you got injured, you can claim insurance. If let's say you got injured, you claim insurance and then you still sue your boss for what do you call it? Not of negligence. Then what's the point? Your boss pay the insurance for you. Your boss pay the insurance in case you really got injured. Then there's the insurance to cover you. So there's this. Before that, there were a few cases that some say yes, some say cannot. But so far, the latest one, we don't know. Maybe there's some changes in the future. So far, the latest one, it says that you follow Section 31 of SOCSO 8. If you claim compensation against SOCSO for injury, you cannot later go and claim tort of negligence against your own employer or even your supervisor in the company. Okay? This is the one I want you to read. Look at that already. Now, in Occupational Health and Safety Act, I just want you to read these two articles that I gave you first. Now, because I said factories and machinery, they combined it. Occupational Health and Safety and Health Act is for the government. It's for a criminal matters. If today at work you climb up the stairs, you fall down, and now the police report has been made, it is for the criminal, the prosecution, the government to sue your employer because they didn't provide a safe environment for you to work. You cannot use Occupational Safety and Health Act to sue your employer for negligence. You cannot. Okay, I think it was clearly stated in Section 50 something. I don't have the act with me. I think it's 54, 52, something like that. Okay, I think it's 52. Right, you cannot. Maybe it's here. Never mind, it's not. It's okay. So it is for the government, as a criminal matter, sue your employer for not providing you a safe working environment, not just in office. If you go out for work field, the work field, you need to make sure that it's safe when you go there. You cannot sue your own employer under this act. It doesn't work like that. This act is not for use to use as civil claim. This act is for the criminal matters. But it's something that we will touch on in maybe some of our questions. Okay? This is what I need you to know. Right? Okay, now come back to our summary. So, we look at the liability. I want you to maybe prepare, okay, that general principles. Look at the cases I asked you to read. Some, if you are lazy, too many, then read the landmark like Siri, Inai, Aokian, Ho. Okay, in particular, general principles of negligence, motor vehicle, medical negligence, private and public nuisance, and also, that's it. Occupiers liability, vicarious, OSHA, this one is not always, okay, but the main one definitely is motor vehicle, public and private nuisance, and also medical negligence, and also the general principle of negligence you must know. Read the case, listen to the podcast, I'll link there, make whatever notes that is needed. Okay? Another week gone by. So I'll again come and text you all by end of this week to see how you are doing, whether you're doing okay, and if you need any help from me. Alright? If everything is good, then we'll stop here. And I'll see you next Monday for... Next Monday, what are we doing? Next Monday, we are still doing a civil procedure. Then after that, we have a question week. So I'll let you know what we do. Okay? Alright. I'll see you next week. I'll text you all. Okay. Bye-bye, everyone. Bye.